Ever felt like you're navigating a maze when it comes to legal situations?
Oh, definitely.
After signing a lease, buying a car, or even just, dealing with a tricky neighbor,
Hmm.
and you just wish you had a crystal ball to tell you your rights.
Right.
Well, today we're taking a deep dive into a fascinating source that promises to be nothing less than a survival guide for non-lawyers.
Oh,
Our mission today isn't to turn you into a legal expert overnight. That's a whole other deep dive.
yeah, that would take a while.
Instead, we're here to extract the most important nuggets of knowledge and insight from this material. We want you to feel, well-informed and confident as you navigate the legal landscape around you.
Hmm.
Think of it as learning to think like a lawyer without having to be one, giving you that shortcut to understanding how the law actually impacts your daily life.
That's precisely it. Our source, Know Your Rights, a survival guide for non-lawyers by Ronald M. Benrey. It really aims to clear up a lot of common misconceptions. It's designed to equip you with enough sort of specialized language and understanding to talk productively with an attorney, or maybe even just find information yourself.
Right.
What's fascinating here is that it's less about the dramatic courtroom battles we see in movies.
Yeah, the Law and Order stuff.
Exactly. And much more about what the author calls the routine legal stew. Those everyday interactions involving contracts, property, personal relationships that kind of subtly shape our lives.
Okay, let's unpack this idea then. Many of us probably think law is just, well, common sense.
Right. That's a big one.
But the source tells us that's often a major misconception. Why is that? And what does it mean for how we approach legal thinking?
It's a great question. And it gets to the core of legal reasoning, really. The law rarely feels like simple common sense because it's fundamentally designed to balance competing interests.
Ah, okay.
Take the example from the source. A renter withholding rent because their landlord hasn't fixed a big plumbing problem.
Yeah, seems fair enough. Why pay?
From a common sense view, maybe? But a judge likely won't just agree straight off. The law in this area is crafted to balance the rights and responsibilities of both landlords and tenants,
Oh, I see.
ensuring landlords get paid, but also obliging them to provide, habitable living conditions. There's no simple common sense answer that satisfies both sides immediately.
Okay.
And thinking like a lawyer often means learning to fill the gap in your understanding. The source gives a powerful example. If someone points a loaded gun at you, that's assault.
Right, obviously.
But what if it's unloaded? A lawyer would fill the gap and conclude that the mere act of pointing a gun, loaded or not, is enough to create fear.
Ah, the fear itself is the key.
Exactly, which completes the assault. The law nearly everywhere agrees because the threat is the key element, not necessarily the immediate actual danger of being shot.
That's a crucial distinction. So if it's not always dramatic courtroom scenes, what do lawyers actually spend their time doing? What does this routine legal stew look like for them?
Yeah, the real answer is far less glamorous than television portrays.
Figured as much.
The majority of attorneys today, and most you're likely to deal with, specialize in what we call transactional law. They spend their days surrounded by paper.
Lots of paper.
Tons of it. Drafting and reviewing contracts, handling real estate conveyances, preparing wills and estates, navigating financial transactions, dealing with business formations, bankruptcies.
But the everyday stuff.
Right. The bulk of legal issues for everyday people involve money, goods, services, and property, the routine legal stew we mentioned. They're less about cross-examinations and more about careful documentation and negotiation.
Let's get clear on the big picture then. Our source divides everyday law into two major categories. What are those?
Those are civil law and criminal law.
Okay.
And the crucial insight here for non-lawyers is that while criminal law aims to punish and involves the state bringing charges against an individual, think shoplifting or assault.
Right. Government versus a person.
Yes. Civil law is about resolving private disputes. The goal there is usually to reimburse harm suffered by one party due to another's actions.
Getting paid back, essentially.
Exactly. So if you're suing for a broken contract or an unpaid debt, you're not trying to send someone to jail. You're trying to get back what you lost, to be made whole financially. It's about money, or sometimes forcing someone to do what they promised, not about taking away their freedom.
Since we're talking about legal systems, give us a quick tour of the courts. Where does all this happen?
Certainly, we have both state court systems and the U.S. court system. State courts typically start with trial courts.
Okay.
These can have general jurisdiction for most cases, or sometimes limited jurisdiction for specific things like traffic violations or small claims, which is where many of us might actually interact with the system.
Claims, yeah.
Above them are intermediate appellate courts, and then the state Supreme Court.
Got it. And federal.
The U.S. court system is often described as a three-layer cake. You have what are called Article III courts. These include district courts, where most federal cases start, and circuit courts of appeals. These are the core permanent federal courts.
Okay, the main ones.
Then you have Article I courts, which Congress creates for very specific purposes, like bankruptcy courts or tax courts. You're probably more likely to end up in an Article III court if you have a federal case.
And the top layer.
And finally, at the very top is the U.S. Supreme Court. Its role includes reviewing the constitutionality of federal, state, and local laws.
Okay, that makes sense. Let's dive into something almost everyone deals with. Contracts. It seems like, a handshake agreement should be enough, right? Your word is your bond.
That's a common sentiment, absolutely.
Yeah.
But legally, it's a bit more complex than just a handshake.
Right.
The source uses the case of the big screen TV to illustrate the 4 essential indicators of a contract that a court looks for.
Okay, what are they?
First, an offer from one party. Second, acceptance of that offer by the other. Third, consideration, meaning something of value is exchanged.
Like the TV for money.
Exactly, or services for a fee. And finally, clear. Terms of the agreement.
Okay.
Now, what's absolutely crucial to understand here, and the source really emphasizes this, is that the law of contract has no interest in stopping you from making a bad deal.
Right.
A court literally doesn't care if the price you agreed to pay is fair or reasonable. If you sign it, generally you're stuck with it, even if it's a terrible deal for you.
Wow. So buyer beware still applies.
In a way, yes, when it comes to the terms you agree to. And remember, in our digital age, what counts as a signature has evolved. Clicking a click-to-complete purchase button, that's almost universally accepted by courts as your binding agreement.
Okay, that's good to know. Here's where it gets really interesting, I think, and hits close to home for many of us. What about those contracts we sign without actually reading, like rental agreements or those endless service terms?
Oh, yeah. We all do it.
Totally. Click, click, agree.
We absolutely do. These are often what are called contracts of adhesion. The chief problem here is, well, significantly unequal bargaining power.
The company versus you.
Right. The stronger party, usually the business, sets non-negotiable, small print boilerplate, often in very complex legal language. The insight here is that you usually can't negotiate these terms. Your only real option is to decline the whole transaction.
Which isn't always practical.
Exactly. Not when you need the service or the apartment. One specific detail to watch for in these is a forum selection clause.
What's that?
These clauses can specify that if you ever need to sue the company, you can only do so in a particular, often really inconvenient location. Like Bismarck, North Dakota for a TV store headquartered there, even if you bought the TV in Florida.
No way.
Yes. It's obviously very convenient for the company and much less so for you. It effectively makes it much harder, maybe even impossible, for you to ever bring a claim.
That's a serious point about access to justice there. Let's shift to consumer products. What are your rights if something you buy is, defective?
You're generally protected by warranties. These can be express warranties, explicit promises about a product's performance or quality.
Like on the box.
Right, written down like on the box or in an ad. But even oral statements made by a salesperson can qualify.
Really?
Yeah. If a salesperson tells you this phone is waterproof down to 10 feet and it isn't, that's an express warranty you might be able to enforce.
Interesting.
Then there are implied warranties, which are presumed to exist by law. The two main ones are the implied warranty of merchantability, meaning the product is fit for its ordinary purpose, like a toaster that actually toasts bread.
Okay, basic stuff.
And the implied warranty of fitness for a particular purpose. That applies if you bought it for a specific known use that the seller acknowledged.
Got it.
Beyond warranties, product liability is key. This imposes strict liability on manufacturers for injuries caused when their product is used in a reasonable manner, even if there was no negligence on their part.
So they're responsible even if they weren't careless?
In many cases, yes. This was a significant shift from the old principle of caveat emptor, or let the buyer beware. It essentially places more burden on the manufacturer, not just the buyer, to ensure product safety.
Speaking of big purchases, what about cars? We've all heard those lemon stories. They can be incredibly frustrating.
Indeed. And thankfully today, virtually all states have lemon laws.
How do they work?
They generally require manufacturers to replace or refund a consistently faulty vehicle and often related expenses like taxes or fees if specific conditions are met, usually after a certain number of repair attempts for the same serious defect or if the car is out of service for a specific number of days.
Okay, so there is recourse.
There is. However, car sales can still involve deceptive practices. Our source warns about common ones.
Like what?
Things like a sales manager suddenly hiking up the price after the salesperson quoted you something lower. Bait-and-switch tactics where an advertised car is suddenly unavailable, but they have a more expensive one for you.
Ah,
Selling repaired new cars that have been in accidents without disclosing it. Or linking financing approval to you buying an expensive extended warranty. Sometimes called yo-yo sales because your financing deal can suddenly change after you've driven off the lot.
wow.
The key insight here is just to be incredibly vigilant and read everything before you sign anything.
Always read the fine print. Okay, from cars and TVs, let's turn our attention to one of the biggest investments most of us make, our homes. Whether renting or buying, what are the key things to know about housing?
First and foremost for renters, always read the lease. Seriously.
I know, but it's so long.
It is, but it's a legally binding contract. It defines so much of your relationship with your landlord. And when you move in, document everything. Any existing defects, take photos, videos. It can be invaluable later if there's a dispute over your security deposit. Proof it was like that when you moved in.
Smart.
It's also crucial to understand the difference between normal wear and tear, which is expected like minor scuffs on an old floor, maybe some fading paint.
Right, just from living there.
Exactly.
Yeah.
And tenant-caused damage, like a hole punched in a wall or serious stains on the carpet, you'd be responsible for the damage, not the normal wear.
Okay.
Now, here's a really powerful concept the source mentions, though many states have banned them, thankfully. Confession of judgment clauses.
Confession of judgment. Sounds ominous.
It was. Imagine signing something that basically said, if my landlord ever thinks I owe money, they can just go get a court judgment against me automatically without me even getting notice or a chance to defend myself.
That sounds incredibly unfair.
Totally devastating, which is why many states banned them. Always be wary of any clause that tries to waive your right to a proper hearing or notice.
Good warning. What if the landlord isn't holding up their end?
If a landlord fails to maintain a habitable condition, basic safety, heat, water, while still collecting rent, you might have a remedy under unfair and deceptive trade practices laws in your state.
And what does that do?
The power of this is that it can sometimes lead to treble damages, meaning your actual damages are multiplied by 3. It's a strong incentive for landlords to, keep the place livable. Knowing this can empower you.
Definitely. What about owning? Condos versus co-ops.
Right. Quick distinction. With condos, you typically own the interior space of your unit in fee simple, like owning a house, and you share ownership of the common elements, grounds, roofs, hallways with other owners.
Okay.
Co-ops, often found in big cities, are different. You don't own the real estate directly. You own shares in a corporation that owns the entire building.
Ah, so you own stock.
Exactly. And in return for owning those shares, you get a proprietary lease that lets you live in your specific unit. It's an ownership of shares, not direct real estate ownership. Different legal structure.
Interesting. Okay, let's move into an area that can be complex and deeply personal. Family law. Marriage and divorce.
Right. The first thing to understand is that states, not the U.S. Constitution, control marriage and divorce laws. So they vary quite a bit from state to state.
No national divorce law.
Correct. A key insight from the source is it's surprisingly easy to establish a marriage, but much more of a hassle to terminate one.
Is it that way?
The term divorce has largely been replaced by dissolution of marriage in many places now. It sounds a bit more neutral, less adversarial.
Okay.
A critical warning from the source. Be really wary of quickie divorces obtained overseas, like from the Dominican Republic or somewhere.
Why is that?
The full faith and credit part of the U.S. Constitution, which usually makes states recognize each other's judgments, doesn't automatically apply to all foreign decrees. Some states might recognize them, but they often leave critical issues like property division and child support completely unresolved.
Creating bigger problems later.
Exactly. Bigger problems down the line. And
Mhm.
just briefly, a few states even permit something called covenant marriages.
Covenant.
Yeah, it's a legally distinct kind of marriage that's much tougher to dissolve. It usually requires premarital counseling and has very limited grounds for divorce, often needing longer separation periods or proof of serious fault.
Wow, okay. Property division in divorce. That sounds like a huge sticking point.
Right.
How do courts handle splitting everything up?
It can be very contentious. There are two main approaches states take. Some states follow community property.
Meaning?
Generally, marital assets, stuff acquired during the marriage, are split 50-50. Pretty straightforward, in theory.
Okay, another way.
Other states apply equitable property distribution. Now, equitable doesn't always mean exactly equal.
Oh.
It often starts with a 50-50 split of marital property as a baseline, but then the judge adjusts the final balance based on a whole list of factors.
Like what kind of factors?
Things like the spouse's age, health, employability, their contributions to the marriage, including as a homemaker, their debts, and the value of any separate property they might have.
So it can get subjective.
Very. The source jokingly refers to it as the state of regret because it can be unpredictable. There's an Old English law saying, equity varies with the length of the chancellor's foot, meaning it can feel a bit arbitrary, which also makes appealing these decisions very difficult.
Right.
It's also vital to distinguish marital property, pretty much anything acquired by either spouse during the marriage belonging to both, from separate property.
What counts as separate?
Things you owned before the marriage, or gifts or inheritances received during the marriage just for you, or, say, a pain and suffering award from a personal injury settlement. That part's usually separate.
But what if you also got lost wages in that settlement?
Ah, good question. The lost wages part would likely be considered marital property because those represent income you would have earned during the marriage for the benefit of the household.
Tricky distinctions. What about prenuptial agreements? Often controversial, maybe seen as unromantic.
They can be, but they serve a very practical purpose, especially if one or both people have significant assets, kids from a prior marriage, or maybe a business they want to protect.
So what can they actually do?
Prenups are most useful for defining how property will be divided if the marriage ends. They can set rules about what stays separate property, how marital assets get split, maybe deal with alimony. They can even serve as a template for a future settlement agreement, potentially making a difficult process a bit smoother.
Okay, but what can't they do?
Crucially, prenups cannot dictate child custody or child support.
Ah, that makes sense.
Those issues are always determined by the court based on the child's best interests at the time of the divorce or separation, regardless of what a prenup might say from years earlier. The court retains that authority.
And what about children? That's almost always the hardest part of divorce, the biggest concern for parents.
It truly is. Custody decisions are always based on the best interest of the child. That's the guiding principle.
Not just who the mother is.
No. Courts no longer honor the old tender years doctrine, which often automatically presumed a young child belonged with the mother. Instead, they look at numerous factors:
Right.
the child's age, gender, mental and physical health, their relationships with siblings, their emotional bonds with each parent, their current living patterns, daily routines, school situation, and even the child's expressed preference if they're old enough, maybe over 10 or 12, depending on the state and the child's maturity.
Okay. And support versus visitation.
It's vital to remember that child support and visitation are separate legal obligations. One parent can't legally withhold visitation because the other is behind on support, and vice versa.
So you can't trade one for the other.
Absolutely not. Doing so can lead to serious legal consequences, like contempt of court findings. And just briefly, it's important to distinguish parental kidnapping, which is a serious crime involving taking a child unlawfully to obstruct custody rights, from what might initially be considered interference with court orders, like being late returning a child after visitation.
Right. There's a difference in severity.
Yes, the repeated interference can certainly escalate. And finally, grandparents' rights to visitation are generally quite limited. Courts strongly uphold the fundamental right of parents to raise their children as they see fit, usually only interfering if denying grandparent visitation would actually harm the child.
What about a major family decision like adoption? It sounds incredibly complicated.
Adoption is wonderfully complex, and the source stresses it almost always requires an experienced attorney. The real insight isn't just the forms, but the why behind the process.
Okay.
For instance, the very thorough home study. It can take months to complete, involves background checks, interviews, home inspections, and it usually has a shelf life of about 18 months. It feels intrusive, maybe, but it's all designed to protect the child's best interest, ensuring a safe and stable placement.
Makes sense.
You also have different types, like direct adoptions, where the birth parents might place the child directly with adoptive parents, versus agency-managed adoptions, where an agency handles things.
And international adoption.
Intercountry adoptions often fall under the Hague Convention, an international treaty. This involves specific U.S. citizenship and immigration services forms, like the I-800A, and requires a critical Article 5 letter from the foreign country confirming the child is adoptable and the placement meets Hague standards.
Visas too, right?
Right. Children receive either an IH-3 visa, granting immediate U.S. citizenship upon entry, or an IH-4 visa if the adoption needs to be finalized in the U.S. The key takeaway is that every step, every form, is ultimately about ensuring the child's well-being and creating a secure, legally sound family. It's a thorough but necessary journey.
Okay, let's consider those everyday squabbles that can sometimes escalate.
Yeah.
Neighbor disputes. They can turn nasty really quickly. What's the legal approach here?
Yeah, they really can. The source rightly advises that court should generally be a last resort for these things. Legal remedies aren't always great, and suing your neighbor.
Yep.
Well, you still have to live next to them.
True. So what's better?
One of the best alternatives, if both sides are willing, is mediation.
How does that work?
It involves a neutral third party, the mediator helping both sides talk and work out their own win-win solution, rather than having a judge impose a winner and loser. The source says mediation for neighbor disputes works upwards of 70% of the time.
That's pretty high.
It is, because it focuses on practical solutions everyone can live with. It's also important to note that the police often view issues like a truly odoriferous compost heap or loud music at odd hours as a civil dispute or a private nuisance rather than a criminal matter, especially if only one person is complaining.
So they might not do much.
They might try to facilitate a conversation, but they probably won't make an arrest unless it escalates significantly or violates a specific noise ordinance. Also, something like a ruined view, maybe your neighbor puts up a big fence, or a shed that blocks your favorite sunset.
Annoying.
Totally annoying, but generally not a valid legal claim. There's usually no right to a view.
Good to know. What about finding things? We've all heard finders, keepers, losers, weepers. Is that actually a thing?
Despite the popular saying, finders keepers is generally not a thing in legal terms.
Really?
The law actually distinguishes carefully between 3 types of found property, and it does this mainly to prevent theft and encourage people to be responsible.
Okay, what are the types?
First is lost property. That's when an owner parts with it involuntarily and doesn't know where it is. Think of a wallet accidentally falling out of someone's pocket on the street.
Right.
The original owner still has the greater legal right to it. As the finder, you generally have a duty to try and return it.
Okay.
Second, mislaid property. This is when the owner intentionally places it somewhere but then forgets where they put it, like leaving your phone on a restaurant table.
Know that.
We all have.
Yeah.
Again, the original owner has the greater right. Often the owner of the place where it was mislaid, the restaurant owner in this case, has a duty to hold on to it for the true owner for a reasonable time.
And the third type? This must be the keeper's one.
This is abandoned property. That's where the owner intentionally gives up all rights to it, like throwing a broken chair out on the curb for trash pickup.
Wow.
That kind of property can generally be claimed by the first person who takes possession with the intent to own it. The key difference in all these is the owner's intent. Did they lose it, misplace it, or truly intend to abandon it?
Makes sense. Lastly, on personal property, what's a bailment? It sounds like a super obscure legal term, but the source says it's common.
It is. It sounds technical, but we engage in bailments all the time without realizing it. A bailment is defined as a temporary transfer of the possession or custody of personal property for a limited period of time and for a specific purpose.
Okay. Like, give me an example.
Think about handing your car keys to a valet parker.
Yeah.
You're not selling them your car, right? You're just temporarily giving them possession for a specific purpose to park it. That's a bailment.
Ah, okay.
Or when you leave clothes at a dry cleaner. Or drop off your computer for repair. Or even borrow a book from the library.
So it's just temporary holding.
Exactly. The key point is that ownership is not transferred. Only possession is, for a limited time and purpose. The person who owns the item is the bailer, and the person taking temporary possession is the bailee. It's incredibly common, just usually invisible.
Got it. Let's move to our constitutional rights. These are, the fundamentals of our liberty, but how do they apply to our daily lives beyond maybe what we learned in civics class?
Right. The Constitution explicitly spells out certain rights: freedom of speech, religion, press, assembly. Those are the explicit rights.
The famous ones.
The famous ones. However, there are also crucial implicit rights. Things like the right to privacy, the right to travel between states, the right to non-discrimination based on certain classifications. These are considered fundamental even though the specific words aren't directly in the text. They've been recognized by courts over time.
Okay.
And a truly crucial concept here, one that's often overlooked but massively important, is the doctrine of incorporation. Yeah. Originally, the Bill of Rights, those first 10 amendments only protected you against actions by the federal government.
Not state or local.
Not initially, but over time, through a series of Supreme Court cases, mostly interpreting the due process and equal protection clauses of the 14th Amendment, which does apply to states.
Okay.
Most of those Bill of Rights protections have been incorporated to apply against state and local governments as well.
So my freedom of speech is protected from my city government, too.
Exactly. Not just from Congress or the president. That's a huge shift in how our fundamental liberties are protected day to day. It makes the Bill of Rights relevant at all levels of government.
Freedom of speech is almost constantly debated. What are the limits? I mean, it's not absolute, right?
Definitely not absolute. It's about real-world consequences. Freedom of speech doesn't include the right to falsely scream fire in a crowded theater if there isn't one.
The classic example.
Right, because that creates a clear and present danger speech that directly threatens public safety and creates imminent danger, like inciting a riot right then and there.
Imminent is key.
Imminent is key. The government generally can't forbid speech just advocating for lawless actions in the abstract. It has to be aimed at producing immediate illegal action and likely to do so.
Okay. Any other limits?
Another category is fighting words. These are words that, as the Supreme Court put it, by their very utterance inflict injury or tend to incite an immediate breach of the peace. Think direct, personal insults likely to provoke violence right now.
So they're like verbal assaults.
Essentially, yeah. They're not seen as contributing to the marketplace of ideas. However, the government can place reasonable restrictions on public forums regarding the time, place, and manner of speech.
Fighting.
Well, as one Supreme Court decision noted, you can't just insist upon a street meeting in the middle of Times Square at the rush hour as a form of freedom of speech.
Right. Chaos.
Exactly. You generally have the right to protest or speak in public places, but the government can set reasonable rules about when, where, and how you do it to maintain public order, as long as those rules are content neutral.
How does the Establishment Clause, the separation of church and state part, play out in public life? This is often misunderstood, sometimes seen as hostility toward religion.
You're right, it's often misinterpreted. The Establishment Clause fundamentally means the government can't set up a church or establish an official religion.
No national church.
Right. Neither federal nor state government can pass laws that aid one religion, aid all religions, or prefer one religion over another. They can't force belief or disbelief or tax people to support religious activities.
Okay, sounds clear.
However, and this is crucial, the source highlights that constitutionally required neutrality toward religion is not hostility toward religion.
What does that mean in practice?
It means if public facilities like schoolrooms, after hours, or park pavilions are generally available for secular groups to use, then religious organizations usually cannot be excluded simply because they are religious or plan to discuss religion. That would be discrimination against religion, not neutrality.
Ah, okay, so equal access.
Equal access is a key principle. This comes up often with things like religious symbols in public spaces. Posting the 10 Commandments might be unconstitutional in a public school classroom because the context suggests government endorsement of religion for impressionable students.
But maybe not elsewhere.
But displaying them as part of a larger historical exhibit in a courthouse or on state capitol grounds might be permissible, seen as acknowledging the historical role of religion in American law and life, rather than establishing a religion. It's very context-dependent. It's about balance, not total prohibition.
And the Second Amendment, that's obviously a huge topic, lots of debate.
It is, and the interpretation has shifted. For a long time, there was significant debate about whether the Second Amendment's right to keep and bear arms was solely a collective right tied to service in a well-regulated militia.
Or an individual right.
Exactly. But in 2008, the U.S. Supreme Court's decision in District of Columbia v. Heller definitively declared an individual right to possess firearms for traditionally lawful purposes, such as self-defense in the home.
So that settled the individual versus collective question.
Largely, yes, at the federal level. The court stated that the inherent right of self-defense has been central to the Second Amendment right. It was a very significant and clarifying ruling, though debates about the scope of that right continue.
Okay, let's shift gears to the workplace. What should you know about your rights as an employee? This affects so many people.
Absolutely. A key area for many non-exempt workers is overtime pay. There's a common misunderstanding here. Many people think overtime kicks in after working 8 hours in a single day.
Yeah, is that right?
Not usually, under federal law at least. The crucial figure is typically 40 hours in a work week.
Per week.
Per week. So working 3 long 12-hour shifts might feel like overtime, but if your total hours for that week are still under 40, you might not be legally entitled to overtime pay. Companies also sometimes run into trouble by misclassifying employees as exempt from overtime when they should actually be getting it based on their job duties and salary.
Okay, what about disabilities?
The Americans with Disabilities Act, the ADA, requires employers to provide reasonable accommodation for disabilities, unless doing so would cause undue hardship for the employer.
What counts as reasonable accommodation?
It can be a lot of things, maybe modifying work schedules, providing special equipment, restructuring job duties slightly, even reassigning someone to a vacant position they can do.
And undue hardship. That sounds like a loophole.
It means something significantly difficult or expensive for the employer to implement, considering their size and resources. But the bar for proving undue hardship is actually quite high. It has to be more than just a minor inconvenience or cost.
Okay. What about privacy at work? Emails, computer use?
Generally, employers have a broad right to monitor employee communications when they occur using company-owned systems.
So my work email isn't private.
Assume it isn't. That includes work email, internet usage on company computers, network activity, even potentially communications on company-issued mobile phones. Your expectation of privacy on company equipment is usually minimal.
Good to remember. What happens if you're injured on the job? That's a terrible situation, but it does happen.
This is where workers' compensation systems come into play. Almost every state has one. It's essentially a no-fault insurance system.
No fault.
Meaning you don't have to prove your employer was negligent or at fault for your injury to receive benefits. If you were injured while working, you're generally covered.
What kind of benefits?
It typically provides payments for lost wages, usually a percentage of your average wage, coverage for medical treatment related to the injury, sometimes retraining if you can't return to your old job, and death benefits for dependents if the injury is fatal.
Okay. Is there a catch?
The main trade-off is that in most cases, accepting workers' comp benefits means you are barred from suing your employer or your coworkers for that injury, even if they were negligent.
So you get benefits easier, but you can't sue for potentially more money.
That's the basic trade-off. It was designed historically because suing employers was very difficult for injured workers. However, you can still file lawsuits against third parties who might have contributed to your injury.
That's cool.
For example, if a factory worker is hurt by a defective machine, they can collect workers' comp from their employer and sue the company that manufactured the faulty machine.
Okay.
Yeah.
So workers' comp protects you from injury on the job. But what about protecting the company's secrets or preventing you from jumping ship to a competitor? That's where non-compete agreements come in, right?
Precisely. Non-compete agreements, or covenants not to compete, are quite common in employment contracts, especially for employees in specialized roles, sales positions, or those with access to confidential information or trade secrets.
Are they always enforceable? They seem pretty restrictive.
They are restrictive, and courts look at them carefully. They will generally only enforce a non-compete agreement if the restrictions, things like the duration of the restriction, the geographical area it covers, and the scope of activities it prohibits, are deemed reasonable to protect the employer's legitimate business interests.
What's reasonable?
It varies, but courts generally won't enforce something that's overly broad. For example, a court might uphold a ban on working for a direct competitor in the same city for 6 months or a year, but probably not a nationwide ban forever that prevents you from earning a living in your field.
Right. Does it matter when you sign it?
Yes. If you sign it before starting the job offer itself is usually considered sufficient consideration to make it binding. If your employer asks you to sign one after you've already been working there, or maybe as part of an exit interview, they usually need to provide some additional consideration like a bonus, a raise, or continued employment, specifically conditioned on signing for it to be enforceable in many states.
Okay, good to know. While we hope, obviously, you never have to deal with serious criminal charges, what are the everyday aspects of criminal law that people might actually encounter?
You're right, serious charges are rare for most. but we all might encounter common situations like traffic stops. And it's important to know that some traffic tickets aren't just fines you mail in. Things like driving without a valid license or mandatory insurance can actually be misdemeanors requiring a court appearance.
Didn't realize that.
Yeah, they can carry potential penalties beyond just a fine. There's also the common crime of shoplifting, which can have surprising legal ramifications, potentially including jail time and a criminal record, even for relatively small amounts, depending on state law and prior offenses.
Okay.
And finally, the concept of being an accomplice. This means someone who is complicit in a crime, even if they don't personally carry out the main act. It could be acting as a lookout, driving the getaway car, or knowingly helping plan it.
And the punishment.
An accomplice is usually considered just as guilty as the person who directly commits the crime and can be punished just as severely.
Wow. So let's say you're pulled over or something else happens. If you're arrested, what's the first thing that happens? What are the triggers for an arrest?
Okay. An arrest is generally justified by one of three arrest triggers. First, a law enforcement officer actually seeing a crime being committed. Second, probable cause.
What's that mean exactly?
It means having a reasonable belief, supported by specific facts and circumstances, that a crime has been committed and that the person being arrested is the one responsible. The source notes this standard is perhaps surprisingly relatively easy to meet. It doesn't require proof beyond a reasonable doubt, just a reasonable basis for belief.
Okay. Example.
Seeing someone run from a store right after a burglar alarm goes off, maybe carrying a bag, that could be probable cause. The third trigger is an arrest warrant, which is a court order issued by a judge or magistrate authorizing the arrest based on a finding of probable cause.
And after the arrest, what's booking?
After the arrest, you typically go through the booking process at the police station. This usually involves things like handcuffing, searching you for weapons or evidence, taking your fingerprints, taking your photograph, mugshot, and sometimes collecting physical samples like hair, voice exemplars, handwriting samples, or even DNA swabs, depending on the alleged crime and state law.
Is taking DNA self-incrimination?
Interestingly, no. The Supreme Court has generally held that providing these kinds of physical samples is not considered self-incrimination under the Fifth Amendment. The Fifth Amendment protects you from being compelled to testify against yourself, to give incriminating statements. Providing physical characteristics is seen differently.
And then comes bail, right? What's the purpose of bail?
Right. Money bail essentially acts as a guarantee, a form of financial insurance, that an arrested person, the defendant, will show up for future court proceedings.
How is the amount set?
Some states have predefined bail schedules for common offenses. Otherwise, a judge sets it based on factors like the seriousness of the charge, the defendant's criminal history, ties to the community, and perceived flight risk. In many states, you have the option of posting a 10% cash bail directly with the court. If you make all your required court appearances, you typically get most of that 10% back at the end of the case, minus a small administrative fee.
What if you can't afford bail?
If you can't afford bail, you might stay in jail until trial, or you could use a bail bondsman who charges a non-refundable fee, usually around 10% of the total bail amount, to post a bond for the full amount. In some cases, especially for less serious offenses or for people deemed a low flight risk, a judge might release the defendant on their own recognizance.
Meaning?
Meaning they're released based solely on their written promise to appear in court without having to post any money.
Oh, okay. What's the point of a preliminary hearing? It sounds like a mini trial, but it's not, right?
That's right. It's definitely not a full trial. The primary purpose of a preliminary hearing, which usually happens fairly soon after arrest in felony cases, is for a judge or magistrate to make an independent determination of whether there was sufficient probable cause to justify the arrest and to continue holding the defendant for trial.
So the judge double-checks the probable cause.
Essentially, yes. The prosecution presents some evidence, maybe testimony from the arresting officer or key witnesses, just enough to show there's a reasonable basis to believe a crime occurred and the defendant was involved. They don't need to prove guilt beyond a reasonable doubt at this stage.
Does the defense present evidence?
Usually not. The defense might cross-examine the prosecution's witnesses, but they typically don't present their own case at the preliminary hearing. Its main function is as a check on the prosecution's decision to charge. If the judge doesn't find probable cause, which is pretty rare if the case has gotten this far, the charges would likely be dismissed and the defendant released.
Finally, the trial process itself. If it actually gets to that point, what should someone expect? Especially thinking about maybe those more common everyday issues, like small claims court.
Okay. Well, the formal criminal process typically starts with the arraignment. That's where the defendant is formally read the charges and enters a plea, usually guilty, not guilty, or sometimes no contest, no lo contendere.
And getting a lawyer.
For felonies, the arraignment is often when the Sixth Amendment right to counsel fully kicks in. If you can't afford an attorney, the court will appoint one for you at or before this stage.
Plea bargaining happens too, right?
Yes, plea bargaining is extremely common. The vast majority of criminal cases are resolved this way. It involves negotiations between the defense attorney and the prosecutor to reach an agreement, often involving the defendant pleading guilty to a lesser charge or receiving a recommended sentence in exchange for avoiding a trial.
What about evidence? Does the defense get to see the prosecution's case?
Yes, that's called criminal discovery. The rules vary by state, but generally, the prosecution has a duty to turn over relevant evidence to the defense. Crucially, this includes any exculpatory information that's evidence that tends to help the defendant's case or suggest innocence. The prosecution must disclose this.
Okay. Now, what about small claims court? You mentioned that earlier. How is that different?
Small claims court is designed to be much more accessible for everyday disputes involving smaller amounts of money, things like unpaid small debts, minor property damage, landlord-tenant deposit issues. The rules of evidence are incredibly relaxed.
Easier for non-lawyers.
Much easier. You typically don't need a lawyer, although you can have one. The judge often takes a more active role in guiding the process, asking questions, and the source notes you usually won't be allowed to just stand there and read from a prepared statement. The judge wants a more conversational explanation of what happened. It's meant to be less formal.
And evidence in general. What kinds are there?
Broadly speaking, evidence falls into a few categories. Direct evidence is something that directly proves a fact, like an eyewitness seeing someone commit the crime. Circumstantial evidence requires an inference. For example, finding someone's fingerprints at a crime scene doesn't directly prove they committed the crime, but it allows the inference they were there. And physical evidence is an actual object, like a weapon, drugs, or the stolen item itself.
We've covered a tremendous amount today.
Oh, wow.
From the nuances of a simple contract to the complexities of criminal procedure and the surprising realities of family and property law. It's really clear that everyday law is anything but simple common sense.
Absolutely. My hope, really, is that this deep dive has given you a clearer understanding of some of your fundamental rights and obligations, maybe empowering you to navigate those legal situations we all encounter with a bit greater confidence.
Yeah.
The truth is, even just a little bit of knowledge about the legal framework around you can go a very long way in protecting yourself and making informed decisions.
And remember that quote from Ambrose Bierce we touched on early in our deep dive?
Yeah.
Lawsuit. A machine which you go into as a pig and come out of as a sausage.
Indeed. It's a cynical view, maybe, but it highlights a truth. While understanding your rights is crucial, sometimes the best legal maneuver is to avoid the sausage machine altogether, often through things like mediation, careful planning, clear communication, or simply knowing when to walk away from a bad deal or seek legal advice early before things escalate.
So here's a thought for you, our listeners, to chew on. If that old maxim is true, that ignorance of the law is no excuse. And we've seen today how the law touches so many aspects of our daily lives, even ones that don't seem that complicated at first glance. What responsibility do you have to maybe dig just a little deeper to try and truly understand the legal intricacies that govern your world?